I have reviewed all of the materials and the applicable authorities. Mr. Hartshorn, it is your motion.
Thank you very much, Your Honor. Again, good morning. We're here on, as you have noted, the Secretary's motion to dismiss or in the alternative for summary judgment. The Secretary is seeking to have this lawsuit dismissed on the grounds that the information that the plaintiffs seek is protected, specifically by MnStat 201.091, which is, as stated in Minnesota statutes, the statute that controls access to information in the state voter registration system, the SVRS, which is the statewide computer database for voter registration information in Minnesota. Now, Your Honor, as you just said, you reviewed our materials. I don't want to go over what we have set out in our materials any more than I absolutely have to. But at least we need to talk a little bit about the background of the SVRS, what it is, and what it consists of.
Mr. Hartshorn, I'm going to have you just slow down a little bit for the record, please. Thank you.
My Achilles heel. Yes. The SVRS is a statewide voter registration database. It was created in 2003 and 2004. It was first put in use in the middle of 2004 in the statewide general primary election. It currently has just a little under 5.5 million registration records in it. Those consist of about 3.25 million records that correspond to currently registered Minnesota voters. And then a little over 2.25 million records of people who at one point were registered voters in Minnesota but aren't anymore. Those folks are dead, or they've moved out of the state, or they've moved within the state but haven't re-registered, as the law requires, or they have failed to vote within a 4-year period and as a result have had their registration removed. Now, the statute calls it registration.
Sir, you need to take off your hat, please. Thank you. Go ahead, sir.
The statute calls it registration removed. What removing a registration actually consists of, however, is just changing the status field on the SVRS record from active to inactive, though. The data is not deleted. The only way that data would be deleted from the SVRS is if there were some kind of data error and a record got somehow copied or something. Short of that, a registration record is not going to be deleted. However, the status of a registration record, active or challenged or inactive or deceased, makes a big difference as to whether and under what conditions that information is accessible under Minnesota law. So, as I mentioned, the crucial statute in this case is MnStat 201.091. And the lion's share of that initial memorandum that we filed was devoted to explaining the structure of that statute and the data access scheme that it sets up. I just wanted to go over, now, in that statute, there are probably 10 or 12 parts of passages that matter in this case. I wanted to go over.
They all matter.
Right. Oh, well, you could point out some spots in the statute that really that for whatever reason don't apply to this case. But there are 4 things in it that are absolutely crucial that the outcome of this case depends upon. And I wanted to go over those 4. The first of those is in subdivision 1 of the statute. And that provision holds that the master list is those 3.25 million records that correspond to currently registered voters. The current list of registered voters in each precinct in each county in the state. Now, the crucial portion for our current purposes of sub 1 is the restriction in that last sentence. The information contained in the master list may only be made available to public officials, and then for particular purposes. That is absolutely crucial in this case because it restricts access to the master list to the currently 3.25 million records that correspond to currently registered voters, and it specifically says that those records are only accessible by public officials, and even then only for specific purposes listed here. In so many words, this is saying those records, that data is at least presumptively not public. And that's crucial under the DPA. This is a Data Practices Act lawsuit. And under the Data Practices Act, all government data is presumed public unless there is some other source of law that says the information is not public. Well, here you go. Here is the provision in 201.091 that says that at least as a matter of baseline presumptive rule, the information on the master list, the information on currently registered voters is not public. That's what this necessarily and on its face means. Now, there is a major exception to that baseline rule, and that's then found in the first handful of sentences in subdivision 4, and that's our second passage that I need to direct attention to. That passage creates what's called the public information list. The public information list is a subset of the master list. It includes some of the data on almost all of the registered voters in the state. Now, it doesn't contain all of each person's record because there are lots of data fields that are in the SVRS for every currently registered voter, but only a small proportion of those data fields are, under the definition right at the beginning of sub 4, included in the public information list. It also doesn't extend quite to every single registered voter for the reasons you can see in the final paragraph of sub 4, but we'll get there in a minute. It's accurate to say that it includes the vast majority of registered voters, and it includes a defined limited subset of the data on those voters that's in the SVRS. Now, another very interesting thing about the public information list is that it's public in sort of a special way. It's not public in the way the DPA uses the word public. Because under the DPA, any information that is public under the DPA, in order to get it, all you have to do as a resident of Minnesota, frankly as a resident of the United States, is send a letter to the relevant commissioner and say, hey, I want that information. If you want a specific piece of information from the Department of Basket Weaving, you can write a letter to the Commissioner of Basket Weaving and say, hi, I would like such and such data. It's public under the DPA. Please give it to me.
Mr. Bertrand, I have to have you slow down.
Still? Okay.
Yes.
Okay. I'm trying. Under the DPA, that's how public information is treated. If someone writes that letter to the Commissioner of Basket Weaving, the Commissioner can't say, wait a minute, you're not one of the people who are entitled to get public information, or I need to see your ID, or you need to sign a statement promising that you're not going to misuse this information. Under the DPA, executive officials are not permitted to do things like that. However, under this statute, the election officials who administer the public information lists are not only allowed to do that, they are at least presumptively required to do that. In order to get access to the public information list, a person seeking it must be a registered Minnesota voter. That is a major restriction. It's not at issue in this case because the requesting party here is a registered Minnesota voter. But still, that restriction is here. The person requesting the public information list must be a registered Minnesota voter. The person must provide identification in order to get access to the public information list. And the person must sign a statement promising that he or she is not going to misuse the data. Now, misuse is my kind of summary word. It's spelled out considerably more explicitly in the statute. So all of this is just to say that what this statute calls public, the public information list, it is public. It is accessible by the vast majority of people in this state, but it's still public in a special sense that's different than the DPA's sense. And what that does is it helps to drive home that this statute is an independent, self-existing source of access law from the DPA. We are not in the DPA universe, and that is driven home again and again in this statute. First, in that last sentence in sub 1, but then also in these access restrictions on the public information list. And I hasten to add again, those restrictions on access to the public information list, they are not directly implicated by this case. The plaintiffs meet those restrictions. Mr. Silac is a registered Minnesota voter. He meets this. He has no trouble signing that statement saying he won't misuse the data. There isn't a problem with those restrictions here. They just, on a theoretical level, show that what we're looking at here is something that is independent of the DPA, that it's intended to be its own thing, not dependent upon, and in fact, displacing the rules in the DPA.
And why didn't the legislature just say that? Because that's not what the statute says.
What isn't what the statute says?
Well, the statute doesn't say this is independent of the DPA.
Well, I think a different.
I have it right in front of me. It doesn't
Right.
say
Well,
that.
the place to look for that particular statement would be the portion of the DPA when it references this, 13.607 sub 6, which says that access to registered voter lists is governed by this statute. That's the explicit statement of that point.
So you gotta take that for Thank you, Brooke.
So, I mean, to the extent that you're looking for an explicit statement from the legislature saying the DPA doesn't control this, what you've got is 13.607 sub 6, which says section 201.091 governs access to registered voter lists. But even if that provision didn't exist, under the DPA, in order to displace the DPA, the restrictions of the DPA, all you need is for that other law to classify data as not public. Well, that's exactly what subdivision 1 does. It classifies the data on currently registered voters as not public by saying it may only be made available to public officials. And then there's the third provision. The provision I'm about to go to has that same necessary implication. That comes in the final sentence of the first paragraph of sub 4. So sub 4, paragraph 1, last sentence, which starts with the words, "The Secretary of State may." And that word may is absolutely crucial here. So what that sentence says is the Secretary of State may provide copies of the public information lists and other information from the statewide registration system for certain uses, and then the sentence ends with relevant limitations. That's absolutely crucial here because, once again, it provides that access to data on this database is not just freely made available to the public. Directly to the contrary, it is made subject to the Secretary of State's statutory discretion by the legislature using the words, "The Secretary of State may provide." May, of course, under longstanding Minnesota law, is permissive, and under a huge iceberg of case law, of which we've only cited the tip, when a statute says that an administrative or executive or judicial officer, quote unquote, may do something, that necessarily means they have discretion on whether to do that or not to do that. That's what these words mean. And that's what Judge Davis in the federal district court recognized that this provision means in the Carlson decision. One thing, just last night looking through this, I noticed that in this statute, in 201.091, the word may is used 7 times. A couple times in the context of may only or may not. But anyway, 7 times. The word shall is in there 9 times. Must is in there 14 times. The legislature is perfectly capable of putting a mandatory requirement on the secretary or other officials. They know how to do that. In this case, they didn't do that. They said the Secretary of State may provide this information, not must. And in order for the plaintiffs to prevail here, that would require this court to effectively amend this to say the Secretary of State must.
Let me ask you a question about subdivision 9 of section
Sure.
201.091.
Mm-hmm.
Because subdivision 9 refers to restricted data,
Mm-hmm.
and it identifies that information that's maintained in the database that must not be included in
Right.
any list
Right.
available to the public.
Mm-hmm.
Why does subdivision 9 provide, as you say in the legislature's words,
Mm-hmm.
the exclusive category of what is restricted data? Social security numbers, date of birth, driver's license numbers, identification card numbers. That's private data that cannot be disclosed.
Well,
Must not.
that must not be disclosed. That's correct.
Okay, so why doesn't that subdivision of 209.091 provide the exclusive list of the things that are private?
Because it doesn't say it does. It does not say that there is no provision of law that says this is the exclusive list of stuff that cannot be provided. And to read that provision together with the restriction in sub 1 about stuff that may only be made available to public officials, and the discretionary authority granted in subdivision 4, the Secretary of State may provide, what subdivision 9 is on its face is a limitation on the Secretary's discretion. The Secretary has the discretion to disclose information for certain purposes, but sub 9 limits that discretion and says, okay, Secretary, and anybody else disclosing SVRS information to the public or to law enforcement, you can't disclose this stuff. And Your Honor mentioned private data, that says this is private data. It doesn't actually say it's private data. It says that it must not be disclosed.
Well, it's restricted data,
Right.
and it can't be disclosed.
Right.
I don't know what any other interpretation of that would be other than it's private.
Well, private data under the DPA can be disclosed under certain circumstances. One issue we're dealing with in this case is that the DPA has technical terms of art: public, non-public, private, confidential, those kinds of things. And when those words get brought into a context in which the DPA, under at least the legislature's understanding of this, does not apply and doesn't have any relevance, is those words bring a lot of presumptions with them. And that's one thing I was trying to do with kind of the meaning of the word public, because public information in the context of sub 4 is slightly different than public information in the DPA case. The data mentioned in subdivision 9 is it's not treated in quite the same way that quote unquote private data is treated in the DPA. Under the DPA, there are circumstances in which government officials can disclose data that has been categorized as private. Under subdivision 9, there are no circumstances under which any election official is permitted to hand out these particular pieces of data to the public or to law enforcement. Now, the argument that I think Your Honor has suggested is that, at least arguably, this list of restricted data, that implies that this is the only data that is somehow protected by the statute, that everything else is fair game, and that everything else is free and available to the public. As I mentioned, that's not consistent with the final sentence of sub 1. It's not consistent with the Secretary of State may language in the third passage that I talked about. It's also not consistent with the fourth passage I want to talk about. But one other thing, that specific argument, that subdivision 9 provides the list of the only protected data here, was offered as one of Plaintiff Stephen Carlson's argument in the federal court in the Carlson case. He was looking for email addresses. Email addresses are some of the information that's on the SVRS. It's information on the database. It's not in the public information list. He argued, well, since email addresses are not listed in subdivision 9, that means they're public. Judge Davis, former Hennepin County judge, now chief judge of the Minnesota District, said no. It does not, just specifically rejected that argument, that subdivision 9 is an exhaustive list of the data that is protected by the statute. But I wanted to talk about one more passage here because I think it conclusively demonstrates that the interpretation of the statute that the plaintiffs offered flatly cannot be true. And frankly, it demonstrates that that reading of sub 9 can't be true. And what I'm talking about, this passage I'm talking about, is the final paragraph in subdivision 4. It's the paragraph that, as our legislative history research shows, that was put there to protect victims of stalking and domestic violence who are concerned that the data that they have, the data about them on the SVRS, could be used to allow someone else to track them down and hurt them. Now, to back up once again, one of the basic concepts in this entire statutory scheme is that the public information list is there. The public information list, again, is a subset of all of the information on the database on currently registered voters. And the idea of this whole structure is that the public information list is the portion, the only portion of the SVRS that is, at least presumptively, accessible to the public. Now, the Secretary of State has the discretion to make other things public, but that's his discretion. Presumptively, the public, as a matter of statutory right, you should say, the public information list is the only portion that the public has access to. That is a necessary and foundational element of understanding of how this statutory structure works. Now, the plaintiff's lawsuit is based on a fundamental denial of that very concept. The plaintiffs, in order to make their arguments, have to believe that that's just not true. That public information list, yeah, fine, that's there, but never mind that, everything is public, or at least everything that's not in sub 9 is public. And so we get access to all of it. And that just flatly can't be true, as this paragraph, this final paragraph of sub 4 shows. What that final paragraph states is that when the Secretary of State receives a written statement from a voter saying, I need my name removed from the public information list for the safety of my family, when the Secretary receives that written statement, the Secretary of State must, that's the modal verb, must withhold from the public information list the name of that registered voter. Now, under plaintiffs' necessary picture, their vision of how data access in the SVRS works, this makes absolutely no sense. There is no way to explain what in the world this is supposed to do. Because all that the statute does is removes particular information from the public information list. If everything on the SVRS is accessible, or everything besides sub 9 is accessible under the DPA, this doesn't protect anybody. Because that stalker, the stalker that this victim is worried about accessing her information, the stalker can just walk in just like the plaintiffs have, submit a DPA request and say, oh, I would like the name and address and phone number of Jane Doe on the SVRS. This is a DPA request, please give it to me.
Wouldn't that fall into the category of data is presumptively public unless there's a state statute, federal law, or temporary classification providing that it's not public?
Well, what would, in that case that I've just described, what would be the law providing that it's not public?
201.091 subdivision 4.
Final paragraph? But that paragraph does not say that data is not public.
It says it must be withheld, so there's a classification.
It says it must be withheld from the public information list. The necessary premise of the plaintiff's lawsuit is that the public information list, that the question of whether data is on the public information list or not is of no public access meaning at all. They are arguing.
So is it your argument that the data is otherwise public, or it's otherwise available to the public, it's just not a matter of whether it's on the public information list?
No, that's their argument. The specific data we are arguing about here, that they have made a broad data request for data on all 5.4 million records on the SVRS. Now, some of the data they've asked for is on the public information list, and the Secretary's response with regard to that data is, sure, you can have the public information list, here you go. Sure. And that has been their response, that, that was the Secretary's response. You can, of course, have the public information list, but they want more. The plaintiffs, what they're arguing here is that the public information list is not all that they are entitled to. They are arguing that they are entitled to more than the public information list on registered voters, because they want information on the challenge status of voters and the history of the SVRS statuses that each of these voters have. That's not on the public information list.
I understand.
Okay, and they claim they have the right to it anyway. They also claim they have the right to all of this information with regard to voters who are not currently registered voters and therefore aren't included on the public information list.
I understand.
Okay.
The request.
Right. So then, in that context, all this paragraph says is that when someone says, I need my data withheld from the public information list for my family's safety, all this says is that the Secretary shall withhold that from the public information list. It doesn't say that it shall be protected from public disclosure. It says it will be withheld from the public information list. According to the plaintiff's lawsuit, it's still public. It's still accessible. And if they are correct, then there's nothing to stop that stalker from walking in with a DPA request, a written DPA request on a piece of paper and saying, I want Jane Doe's name, address, and phone number. This is a DPA request. I have the statutory right to it under Chapter 13. Give it to me. Because nominally, all this paragraph does is remove that information from the public information list. What that proves is that from the legislature's perspective, removing information from the public information list means protecting it from public disclosure. I mean, it's an analytical jump that Your Honor just made, and correctly. You correctly inferred from the fact that, okay, this data has been withheld from the public information list, you inferred from that to, well, this data, therefore, is not accessible to the public. That's right, but that is specifically
I don't think I inferred that.
Okay, you hypothetically inferred it?
Mr. Hartshorn, I mean, one of the problems is that's inconsistent with what you said earlier, and that is the legislature knows how to say things when they want to say them. And if they intended to make this data private, then they would have said, we're going to make this data private and not accessible ever, under any circumstances.
Well,
They could have put it in category 9, restricted data.
They could.
But they didn't.
Right, because that's not how they want this particular data treated. What they've done is they've said that the master list, information on registered voters, is presumptively non-public, but there's this thing called the public information list that is accessible to the public, and the Secretary of State has discretion to disclose or not to disclose SVRS information in general. The result of that structure is that information that's not on the public information list is presumptively not available to the public, and it's subject to the Secretary's discretion. That is the status of Jane Doe's information. It's presumptively not accessible by the public, and it's subject to the Secretary's discretion. That is how this has been set up. So the legislature has said that. That's what they've said in the final sentence of sub 1, in the final sentence of sub 4, paragraph 1. They've set it up that way, that the public information list is the portion that is available to the public, and everything else is at least presumptively not available to the public. And then sub 9 is stuff that just is ironclad, never available to the public. So that's the situation that we are in with regard to the information in sub 4, the final paragraph. All that it says is that data must be removed from the public information list. And if the plaintiffs are correct, that protects nothing. A stalker waiving the DPA can come get that information instead. And that's absolutely patently not what the legislature intended. If the DPA permitted the plaintiffs to access this information, and to be clear, the plaintiffs are demanding precisely this information. There is some number of hundred registered voters. I talked to the state election director yesterday. He said he'd have to run a query to get an exact number, but there's somewhere between 200 and 1,000 currently registered Minnesota voters who have invoked their rights under this paragraph. In so many words, the plaintiffs in this case are demanding the name, address, and phone number of every single one of those people. Now, they're also requesting the name, address, and phone number of 5.4 million other people. But if I'm a stalker looking for one of those particular people, I'm not too worried that I'm going to have to run a little database query. So, the notion that this paragraph protects those people's information is simply irreconcilable with the necessary legal premises of the plaintiff's lawsuit. Because the plaintiffs are directly demanding, and if they win the case, they will get the very names and addresses and phone numbers this paragraph has been used some number of hundred times to protect. And that is a serious problem just in terms of public safety, if nothing else. We can't allow that information to be disclosed. And then I suppose just from a statutory construction perspective, this paragraph requires someone to make out a written statement that says, safety requires my data to be removed from the public information list. If the plaintiffs are correct that removing something from the public information list doesn't protect it from disclosure, if the plaintiffs are correct about that, then the statute requires the person to file what amounts to a legal falsehood. And that's nonsense. The legislature would never do that. Now, just the one last thing. Those are the 4 provisions that we believe really need the court's attention, especially.
I'm just looking at Exhibit B to the complaint, which is Mr. Black's response to Mr. Seelek's request, data practices request.
Right.
And the secretary did not carve out any of the public safety information that you are claiming is so sensitive at this point in time from the information that the secretary is promising to produce.
That's right, because the operation of that paragraph that we've just been looking at is that that information gets removed from the public information list.
Okay.
And what Mr. Black is saying here is, sure, plaintiffs, you can have access to the public information list, that's fine. The rest of this stuff you can't have.
And just, he's presuming, at least your representation today is, he's presuming that the data that would qualify in the last paragraph of
Yep.
subdivision 4 is not on that public information.
Right, that is precisely what that paragraph
I
says.
understand.
Yeah. So the last thing that then I would point to, Your Honor, is the legislative history. Now, the Secretary's belief is that this statute is clear, is that the structure it sets up, especially in those four provisions I've just gone through, is not ambiguous. That it's clear that that's what the legislature is trying to do in the statute. But maybe Your Honor disagrees with that. If so, okay. The Minnesota statutes provide a process by which that the court can determine what an ambiguous statute means, and a crucial element of that is the contemporaneous legislative history of the statute. And this statute, the legislature has come back to the statute many times since it was enacted, at least 3 times since the current SVRS went live in 2003, 2004. And we have provided specific legislative history evidence, information, with regard to recent revisions to this statute. I don't believe that there are relevant revisions to this statute since the SVRS went live that we have not provided information about. I don't think there are. There could have been other failed amendments that we didn't catch, but at least the 2 successful ones, I believe we've got in here. And what all 3 of the bills that we have evidence on show absolutely uniformly is that the legislature understands this statute to operate in exactly the same way that the Secretary understands it. And the fundamental point there is that the legislature understands it, that the public information list is the part that's available to the public, and everything else is not. That's just taken as an underlying given in the entire discussion. And so, in the 2005 revisions, the 2005 amendment to the statute was on that paragraph we just talked about. That paragraph used to say that if you want your information removed from the public information list, you have to submit a protective order or some other kind of legal document showing that you're in trouble. In 2005, they weakened that restriction. They lowered the bar so that someone just has to provide a written statement. And in the legislative history that we have provided in the transcripts, the legislators involved in this amendment made clear what they were trying to do. They were trying to permit people to take their information off the public list, they just called it the public list, and make it not public. The legislature clearly understood that the public information list was the public stuff, anything not on the public information list was not public stuff. If that's correct, this lawsuit must fail, because everything we're fighting about here is stuff that's off the public information list. The stuff that's on the public information list, plaintiffs have been happily granted the right to get. There is no dispute that they have every right to access the public information list. That's the 2005 revision. In 2016, the legislature provided the newest portion of the definition of the public information list. In 2020, we're going to have a new presidential primary. And now, for the first time, which party's ballot each voter chose is going to be one element of the public information list on each voter's record in the public information list. And that is a new provision, and precisely that was debated in 2016. And again, the whole debate was, do we make this information public or do we keep it private? And the necessary presumption of the entire discussion was putting that information on the public information list makes it public. Keeping it off the public information list makes it not public. Removing that presumption makes the entire discussion, the entire legislative history that we've provided, absurd. Finally, in 2017, earlier this year, there was an attempt to make precisely the data that these plaintiffs are seeking. Precisely the stuff that they want to see on currently registered voters, but isn't on the public information list. Specifically, they want information on challenge status and other statuses like inactive voters, and they want to know the history of those statuses and the grounds for any challenge or inactive status. They want to know that. Well, the bill in earlier 2017 would have put those pieces of information on the public information list. And even the sponsor of this bill, one of the affiants for the plaintiffs, Senator Kiffmeyer, admitted, yes, this makes new information public. Putting this information on the public information newly makes information public. The legislature looked at that, looked at the possibility of newly making that information public, specifically a core part of what they're trying to get in this lawsuit, and the legislature said, no, we are not going to make that information public. Having failed in that legislative amendment, plaintiffs came here, filed this lawsuit. Okay, we can't get it through the legislature, we'll try to get it through the courts. The legislature has decided they're not going to change the public information list to include the information we want, so we'll file a lawsuit and claim that we get it anyway. Now, we've cited a fair amount of US Supreme Court precedent that shows that when the legislature rejects a particular legislative policy, that courts are not in a good position to then just grant that same relief that the legislature has just rejected. So, at least in my remarks in chief, that's what I've got. I'm happy to answer any other questions that Your Honor has. I mean, certainly about the statute or about anything else that's been presented. Otherwise, I'll sit down and give Mr. Cardall the podium.
The only last question that I have for you at this time, Mr. Hartshorn, is one that I'm going to ask Mr. Cardall as well, and that is this a question that should be certified to the Minnesota Supreme Court? And if so, what question should be certified?
I don't believe so. I mean, Data Practices Act cases are, I mean, at least in cases like this, maybe always, are fairly straightforward matters of statutory interpretation. That's certainly within the jurisdiction and very much the competence of this court. If either party doesn't like the construction that Your Honor places on this statute, certainly both have recourse to the Court of Appeals and if necessary, the Supreme Court. So I don't see a reason why this would need to undergo a process other than the normal.
The reason I ask that is because you do mention in your brief that this is a case of first impression with respect to the interpretation of Section 209.091 as it relates to the Data Practices Act as well. So the interplay between those two statutes is one that I have not seen addressed in any of the cited authorities other than the advisory opinions issued by IPAD.
Well, there was, of course, the McGrath decision from the Court of Appeals.
Yes.
Which
yes, I understand.
Okay, so there is that, and insofar as the Carlson case provides persuasive authority, that the Carlson case it's a federal decision, but it holds that the Secretary of State may language grants to the Secretary discretionary authority. Now, I don't know that.
You're not asking for certification.
No, that's correct.
Thank you.
Thank you.
Mr. Carl.
Good morning, Your Honor.
Good morning.
I'd like to start just with your last question. I haven't had a chance to talk to my clients, but there's a sense of urgency with respect to election administration in Minnesota. We've had a lot of close elections, especially governor, and my client, the Minnesota Voters Alliance, is interested in certification at the Supreme Court in part because the appeal process can take a long time. So what could happen is either side wins, and then there's a year at the Court of Appeals, and then there's another year, and then all of a sudden we're beyond another election. And from our point of view, the delay that we've already suffered is harmful because the election now is only a year away, and it's so difficult. Once you get the data, then you have to analyze the data, and then you have to come up with how to improve the system if there's a problem. The Minnesota Voters Alliance has a lot of credibility as a nonprofit. It's been working for years regarding election administration oversight and educating the public. Contrary to what the Secretary of State has said, they have had many successes in court and at the legislature. They're involved in the Secretary of State's constitutional ballot and titles litigation. They're involved in online voter registration in this court, involved in legislative reform with respect to the Department of Corrections and the court system reporting felon data more frequently to the Secretary of State to update the lists. They've been concerned about campaign disclosure when school districts and cities use taxpayer funds to get bond referenda passed, because the taxpayers want to know if money is being used to campaign for a bond referendum, how much is being spent. And then finally, on political apparel, we've had a dispute with the Secretary of State for almost 10 years now about political apparel at the polling place. The Secretary of State wants to turn people away based on what they wear, and now the U.S. Supreme Court has taken jurisdiction over that case. So the Minnesota Voters Alliance is homegrown. That means it's Minnesotans, and they're authentic. They want election integrity, and we need data under Chapter 13 in order to analyze that. Now, we're here for one reason, and that is the Secretary of State has taken the position that this public information can be concealed when we need it to improve the election administration. For example, the data we requested are critical for assessing whether persons marked felony challenged, among others, have been permitted to vote while they're ineligible. The Secretary of State's principal argument with respect to this very important data is that the Secretary of State has unbridled discretionary authority. The Secretary admits there's nothing preventing the Secretary from releasing the requested information except the Secretary's unwillingness to do so. Here's what the Secretary of State argues in the reply brief. Subdivision 4 grants the Secretary discretion to determine whether or not to disclose SVRS information that lies outside of the public information list to the public. So both sides agree on some fundamentals here. The requested data exists, and it's under the Secretary of State's control. 2, nothing prevents the Secretary of State from allowing the public to see the data. I know there's one caveat here with respect to the subdivision regarding stalkers, but we could deal with that separately. Then finally, and this is important, Judge, and it goes back to certification of the Supreme Court, the Secretary of State has no written policy allowing the public to see the requested data. So not only has the court identified a question that's cert-worthy to the Minnesota Supreme Court, but also the Secretary of State has no policy. So what we're doing here is the Attorney General's office has been writing these briefs as if to create a policy on the run. And that's very disconcerting, particularly when the Secretary of State is claiming unbridled discretion. So this information is provided to some people, but not some people and not others.
Mr. Carl, just a little slower for the record, please. Thank you.
So now for the smoking gun, Your Honor, and this is important, maybe directly to the statutory interpretation question, but most importantly, what is this fight about? Because it's not happening in a vacuum. And the Minnesota Voters Alliance and the Secretary of State have a very long relationship at the legislature, in the courtroom, and elsewhere. They know each other. They know what they've been doing. Here, the smoking gun is the Secretary does not want to release the information because the Minnesota Voters Alliance wants to review the data for election administration purposes. So I even offered a CLE on this. That is, how difficult it is to get data when you're requesting data from the government entity you're criticizing. Now, our demonstration here with Andy Seelick's declaration, Exhibit A1 through A10, is that there's a reason that the Secretary of State does not want to refer to these exhibits. The reason is the poll rosters that were provided by the county auditors show conclusively that the Secretary of State releases the requested data to the county auditors. That's how we got the information. In those 10 pages of poll rosters, there are 11 marked challenge felony, 3 marked challenge postal return. That means the address was not verified after the election. So at this point, the Secretary of State argues, I used this information in the election administration process. I can use it how I please and give it to whom I please for no stated reason. The Secretary of State claims arbitrary authority to withhold that information from the public, even though it's using the information in a very public way in the election administration system. These poll rosters also show why the Secretary of State doesn't want the MVA to have the requested data. As Andy Seelick declared in his declaration, paragraphs 13 to 18, here Mr. Seelick relates that using the individual information about challenge felony on the poll roster, he was able to determine that it is very likely 7 of the 11 persons marked challenge felony were not eligible to vote on November 4th, 2014 in Hennepin County. So we can verify whether the Secretary of State's manual, the questions that are asked at the polling place, and whether the Secretary of State's choice of doing it this way on the roster is actually working to prevent eligible people from voting. The MVA is interested in reviewing more records in the 4,000 precincts, determine the extent of the problem of ineligible people voting, and then proposing to the Secretary of State how to fix it. There is I want to mention, because of the years of litigation with the Secretary of State's office, Your Honor, the Minnesota Supreme Court has said that our election system can have two goals which are compatible. One is maximizing the turnout of eligible voters, and two, precluding ineligible voters from voting. Now, the Secretary of State's position taken in this courtroom before the 2016 election was that discouraging ineligible people from voting discourages eligible people from voting. And that's, from our point of view, just hogwash. That the Supreme Court has said you can have these two goals, they're compatible. And saying no to ineligible voters voting has nothing to do with maximizing turnout at an election. Now, with respect to the specific points that we want to show that the Secretary of State is not fairly interpreting the law, we want to point at the DPA as designating a watershed event in 1991, designating all government data as public data that a person is entitled to get upon request, and the second statute, 201.091, which is very specific about providing the public voter registration information. It's important, Your Honor, to understand that 201.091 has a different purpose than the Data Privacy Act. 201.091 was enacted in 1990, and when we step back, and I've listened very carefully and read all the briefs that the Secretary of State has submitted, 201.091 deals with a practical political problem that relates to the appearance of impartiality of the Secretary of State's office. All of us want our candidates, want our campaigns to have the information about the registered voters so that they can communicate. The purpose of 201.091 was to standardize the rules so everyone was treated fairly. If you didn't have 201.091, what would happen would be one candidate would allege that the other candidate was getting the information faster or more easily from the Secretary of State, and you would have that kind of back and forth. 201.091 was not a restriction on the Data Privacy Act. In fact, 201.091 creates greater obligations on the Secretary of State to make information publicly available to all candidates and campaigns and so forth, so that it can have the information in a timely way prior to the election. That's why it has to be produced within 10 days of the request. There is no similar provision in the DPA. So they're two completely different purposes, and that's why the connecting provision, remember 201.091 was enacted, the relevant provision, in 1990, and the DPA in 1991. In subdivision 6 of 13.607, it says registered voter lists, access to registered voter lists is governed by 201.091. So what does that mean? That means that the manifest intention of the state legislature was to make sure that 201.091 and the obligations to make registered voter lists readily available candidates and campaigns within 10 days would stay put. As the court knows, the DPA, you make a request and the government has a reasonable time to respond. And so it's a much different system. The registered voter list must be made publicly available in a certain way, whereas the Minnesota Government Data Privacy Act provides a different way to provide a person requesting the information. In the Secretary of State's reply brief, there was almost a manipulation of the phrase registered voters list. Access to registered voters list is governed by 201.091. The Secretary of State stretches it to suggest that this basically exempts the Secretary of State from the Data Privacy Act. That it means that the Data Privacy Act doesn't apply to the Secretary of State. Well, that's a gloss on that provision. Like the court suggested by some of the questions, well, if that were true, why didn't the state legislature in 1991 say it? Rather, what the state legislature said was, basically, you have all these rights, and people, you have more rights to get registered voter lists under 201.091. With respect to 201.091 subdivision 4, it describes what shall be on the public information list, and it refers to voting history of each registered voter, along with name, address, year of birth. Well, with respect to registered voters, the Secretary of State has now taken the position that there's some sort of classification of non-registered voter. But yet, all the information regarding voters who have been registered in the past is in the SVRS. And Chapter 201 regarding voter registration applications says that you register or update your registration. Our view is that once a registered voter, always a registered voter, you're welcome to come to the polling place. I mean, it's a very strange thing that the Secretary of State wants to promote turnout, that we'd be talking about people not being registered. Our view, consistent with Chapter 201, is that when you fill out an application for voter registration and you've already been registered, you're updating, because we want to make it welcoming to everyone. So the idea that the voter registration list, the public information list, would not include all registered voters, that is everyone in the system, is contradictory to what subdivision 4 unambiguously states. With respect to voting history, it's important that the court understand that the phrase is voting history. So voting history in subdivision 4 would refer to the past elections. It wouldn't just be one election. And so we are requesting the data under the Data Privacy Act, but the court should not be misdirected by the manipulation of the phrase public information list. So in other words, if the Secretary of State has all this discretion, then the Secretary of State is relying on the public information list to say, this is what the public gets, this is what the public doesn't get. Then at the very least, the Secretary of State should be following subdivision 4 that says you get the voting history of each registered voter, which ends up being exactly the information we want. And so there's a problem with this grand argument the Secretary of State's making that the 201.091 carves out an exception to the Data Privacy Act, because actually there are two jobs here, one under the Data Privacy Act for the Secretary of State to do, and one under 201.091. The Secretary of State acts as if one job replaces the other, but actually there are two jobs, and under both statutes we get the information requested. This also brings us...
Just to be clear, Mr. Cardle, it's your position that all the information that you're requesting is within the ambit of subdivision 4 of section 201.091?
Yes, it should be on the public information list, and that's not that there couldn't be two public information lists. Maybe someone requests the public information list a certain way or otherwise. The Secretary of State can meet the obligations to provide the public information any way it wants, in any way that's usable for the consumer, much different than the DPA. But all this information should be available, because this is the way the people monitor their elections, this one in the past, and it's important with respect to election administration. Again, I can't repeat enough the sincerity of the Minnesota Voters Alliance, that for years they've been working on these issues and they want to help. And this court is a court equal among equals. This has been reported in the newspapers over and again. The Ramsey County, because it's the jurisdiction over the state offices, the principal offices of the state agencies, it gets really important cases. And this case is important with respect to self-governance. Like, how are we going to operate? Are we going to operate in a way that the Secretary of State provides us with information so we can analyze it and make constructive input? And then the bigger question is, was this resolved in 1991 when the people of Minnesota enacted the Minnesota Data Privacy Act? The Minnesota Data Privacy Act establishes that this is the way Minnesota is going to be governed. The people are going to get the data of what the government's doing, and then people can make constructive inputs. Now, to the extent that there's been disparaging remarks about the Minnesota Voters Alliance, to the extent the Minnesota Voters Alliance with respect to election administration has a bad idea, there are gatekeepers called the state legislature, the gatekeepers, the courts, and they can stop bad ideas. They can stop bad ideas, yep. And so when I move on to this next phrase, which was critical to the Secretary of State's argument, the use of the word may, we simply pointed out that when the word may is used in this sentence, the Secretary of State may provide copies of the public information lists and other information from the statewide registration system for uses related to elections and so forth. We pointed out that may modifies public information lists and other information. So then the Secretary of State responded, well, the may does not apply to public information lists because there's other language in the statute that says shall. But the may ends up being, the may can't mean both things. May can't, this is just one may, it's not two mays, or the 9 mays my friend representing Secretary of State mentioned. This may can not mean both things. May does not mean in one instance that shall with respect to public information lists and may with respect to other information. So that means that the Secretary of State has argued that may has two meanings in the same sentence. And it doesn't even make any sense. Plus, that can't be the basis for repealing the DPA obligations of the Secretary of State. Regarding McGrath and Carlson, a close reading of Carlson, there's a successful argument regarding the 11th Amendment preventing a federal judge from interpreting state law obligations on a state official. And you know, we agree with that, we're in state court, but nothing that the judge did actually got to the questions we're discussing because the state official had immunity. With respect to McGrath, that was a HAVA case, and I don't think it's very helpful here, so it is an issue of first impression. The subsequent legislative history, it's not relevant. Plus, one of the dangers of reading the tea leaves of legislators talking about laws is that the court would have too much discretion, and so the court shouldn't venture into that. In fact, former Secretary of State Mary Kiffmeyer, who was a legislator at the time, filed an affidavit saying the inferences the Secretary of State has made from those discussions is inaccurate.
Mr. Cardell, you also agree that the statutes at issue are unambiguous?
Yes, I agree that they're unambiguous, and I think that when we look at the statutes and we look at the sequencing of the statutes, and this is you know, sort of what came first. So we look at the 1990 201.091 enactment and we say, okay, the state legislature was dealing with how do we make sure that campaigns and candidates are treated fairly to get the public information list, and how do we make sure they get the information quickly so they can use it during an election. And that's why there's a short time frame for the Secretary of State to make the information available and make it available to everyone. With respect to the later act,
Sorry, I have to slow you down a little bit for my court report. I want to make sure we keep an accurate record.
Sure, and with respect to the later act, the 1991 Data Privacy Act, I mean, it was a huge watershed. I mean, the 1991 Data Privacy Act was really the fundamental first step to sort of modern government, the idea that the people will have opportunities to know what their government's doing and to make contributions through the state legislature, through other forums at the city and county and township levels, school district levels. And that was all just very, very important. And the framework in subdivision 3 was state legislature can designate what is not public by statute. And so the court had recognized some of that language in 201.091 that would qualify for making things non-public. For example, in subdivision 9, the legislature mentioned social security numbers, date of birth, driver's license number, that type of information would be not public. The state legislature, even in that provision regarding stalkers, I think it's at the end of subdivision 4, that a person can petition to keep their voter information confidential upon a showing of good cause. And so there, that would be not public. So the state legislature has found ways to describe what's not public. The challenge here is to find in these statutes, amongst the Secretary of State's claims of unbridled discretion, where does it say that felony challenged and voter statuses are not public? And this is information, as I started, that the Secretary of State uses in the election administration system. So, for example, Your Honor, as we've shown, the Secretary of State is using the challenge fields on the poll roster. Mr. Seelig has gone to the poll roster and seen that, well, ineligible people are voting. And now he wants to see from the Secretary of State, well, how big a problem is this? Is it thousands of people? Is it hundreds of people? Where are the problems? Why are the problems occurring? Is the problem that the Secretary of State's manual has a question that says, well, are you eligible? And if the ineligible felon says yes and it was willing to self-certify, they're allowed to vote. Then only afterwards we check to see if they're definitively, I guess, ineligible. All those questions are fair questions, but we need the data. And what the Secretary of State is saying is we're not going to give you the data because we have discretion, but there's no specific provision saying that data is non-public. In fact, it should be on the public information list, or 21091, and it's available under the DPA.
Let me ask you a couple of just questions about how the SVRS works, and I'll ask Mr. Hartshorn these questions as well. My understanding is that the public rosters, or the polling rosters, are public because of the 2 iPad opinions. Is that correct?
That's my understanding.
And then you and Mr. Seelick and the Minnesota Voters Alliance have requested and received copies of those polling rosters, correct?
Yes.
And are those polling rosters the origin of the data that is inputted into the SVRS about the voters, including their challenge status?
Yes, it goes both ways. The information, the auditor receives information from the Secretary of State, and then the auditor puts information that's received by the Secretary of State.
So the question I have is, and this is really a question for Mr. Hartshorn, is why is the data public if it's requested in Form A, but becomes private if it's requested in Form B? Is that really the issue here?
It is, and for us, and this is the idea that we think is behind the DPA, if the information is public, then we should get it in a convenient way. And the Secretary of State is saying basically, go to the 87 counties and get it, and then compile it yourself. But we think because it's public, the Secretary of State should give us the information in a way similar that it produces the public information lists.
I understand.
Thank you, Your Honor.
Oh, one other thing before I have Mr. Hartshorn speak. Mr. Cardall, I know that I raised this issue just for the first time today about whether you like the question certified, and if you do want a certified question, what that question should be. I'm happy to give you and your clients an opportunity to talk about that and make a submission by letter to the court as to if you want a certification and what that question should be. If you want to do that, I can give you until the end of the week if that would be enough time for you.
Yeah, I know that my client will want to certify it for no other reason, Judge. No offense to the court, but for the reason that that it would be faster, because we suspect the Secretary of State will appeal whatever decision the court makes.
All right, but I want to know what the question is that you would like me to certify, and I want to give you an opportunity to talk to your client about what that would be.
All right, thank you.
Okay, thank you. Mr. Hartshorn, can we start with the question that I left off with Mr. Cardall, and that is, if we're all correct that the data that's being requested by the plaintiffs is available on the polling rosters, but now is not available because the Secretary has exercised his discretion to say it's not going to be on the public information list and therefore not available, how do you reconcile that?
Well, in large part, it's simply not true that most of this information is available on polling place rosters. Remember, they are looking for a huge quantity of information with regard to all 5.4 million records in the SVRS.
Okay, well, let's just carve out the piece of it that is demonstrably publicly available, attached to Mr. Seelick's affidavit, the challenge status of the voters.
Okay. Well, the challenge status of people who are not currently registered voters is not going to be on any polling place roster. They want the challenge status of all 5.4 million of those people, and a good 40% of those they're not going to be able to find on a polling place roster because those people haven't voted in a very long time.
Okay, but now let's talk about the people who have voted,
right,
where they do have records,
right,
that they have received through a data practices request.
Right.
That the
to a county auditor, not to the Secretary of State.
Okay,
yes.
so they're asking for the same data from 2 different public officials.
Right.
And one is saying yes and one is saying no.
Right.
So how do I reconcile that under the Data Practices Act?
The Data Practices Act is very clear in many contexts that the same piece of information, when it appears in 2 different statutory contexts or 2 different information contexts, can have different statuses.
Then how do you reconcile that with the Minnesota Supreme Court's decision last year in the KSTP case, where they indicate that the Data Practices Act has a single purpose reading, and
Sure.
that data data is data, it's either public or it's private, it's not both.
Right. Well,
So how do we reconcile that?
because, well, I don't think that ruling is contrary to what I'm trying to express here, which is that the same piece of information can be private in one context and public in another context. A perfect example is Social Security numbers. Social Security numbers, again, under sub 9 of 201.091, a Social Security number that appears on a voter registration record cannot be disclosed to the public under any circumstances. However, under MnStat 13.355, that same Social Security number is considered private data on individuals, presumptively, but there's an exception for the county recorder or registrar of titles. So when that Social Security number appears on documents or records filed or recorded with the county recorder or registrar of titles, then that same Social Security number is public. So the same piece of data can be public in one context and private in a different context. That's absolutely possible under the law. And the polling place roster is a different thing than the SVRS. One major difference, which certainly makes a huge difference to my client doesn't have any polling place rosters. My client doesn't print them, doesn't administer them, doesn't have any direct connection to them. This is not a lawsuit for polling place rosters because the secretary doesn't have any polling place rosters. All he has is the electronic database. A polling place roster is initially and originally generated from the SVRS, but once it can be reviewed by somebody, it's now a different thing. It has now gone to a polling place, and some people have signed in and signed the oath on it that says, "I swear that I'm eligible to vote," and has been permitted to vote on that basis. And that is a different context, just like the DPA distinguishes between these county recorder or registrar documents and other documents to say a Social Security number. Over here, it's private. Over here, it's public. And under 201.091, it's super private. It can't be disclosed to the...
I need you to slow down for
Okay.
the record, okay? Thank you.
It can't be disclosed to the public under any circumstances at all. Now, I should say, you're correct that there are a couple of IPAD decisions that say polling place rosters are public, and IPAD has ruled that. We should note, no court, at least that I'm familiar with, has ruled that, has applied the DPA to them, has applied 201.091 to them. I'm not aware of a statute, other than arguably the DPA, that says polling place rosters are public. At least one of those IPAD decisions says that, 201.091 ought to apply to polling place rosters for consistency. Well, is that right? I don't know, maybe. But it certainly isn't clear from the face of this statute that this statute applies to polling place rosters. Polling place rosters are different from the database. So I don't think it makes sense to use as a premise, well, polling place rosters are clearly public. Neither am I trying to represent that they are private. And it is true that county auditors in some counties have determined, yes, they are public. And the secretary has a rule in the secretary's chapter that permits, that has regulations on access to polling place rosters. So that's fine. At least they are treated that way at this point. Nonetheless, 201.091 is quite clear. And the legislature, in discussing amendments to the statute, has made clear that it is quite clear to them how SVRS data is to be administered and is to be treated. And if that data is treated differently under this statute's explicit provisions with regard to the SVRS, then similar or related data is treated in the polling place roster context, well, then that's just the way things are, and the law can make distinctions like that, just like the law makes distinctions with regard to Social Security numbers. I should say as well that Mr. Carlson, in the federal case, he made precisely the same argument about email addresses. He wanted the complete list of email addresses of all the voters in the congressional district where he was running for Congress. And the secretary opposed that request on precisely these same grounds, saying the public information list does not include email addresses, therefore they're not public, and you can't have them. And Mr. Carlson argued, but wait a minute, the secretary has these other email addresses that he got from a different source other than the SVRS, and the secretary treated those as public, which they are under the DPA. Surely many of those email addresses are the same as the email addresses in the SVRS, therefore the ones in the SVRS are public. And the Carlson court directly rejected that argument. The fact that a particular piece of information is classified as public in one context does not imply that it's public in a different context. The only suggestion we have, sort of, by a citation of a citation in this case, is an IPAD decision saying they should be treated the same way for quote-unquote consistency. That's an interesting legal idea. Surely that cannot overcome the explicit provisions of 201.091, which do, on their face, protect SVRS data from public disclosure. Now, there's some things that Mr. Cardall said that I have to respond to. One of them is the notion that that we are arguing the Secretary is unbridled discretion. Come on. That is not what the statute says at all, and that's not what the Secretary has argued. The discretion that's provided by the phrase the Secretary of State may provide is not unbridled. Right at the end of that sentence, it says the Secretary may provide copies of these SVRS records for uses related to elections, political activities, or in response to a law enforcement inquiry, et cetera, et cetera. That puts a bridle on the discretion. That puts a limitation on the grounds on which the Secretary can disclose this information. Another bridle on this discretion is subdivision 5, which says, it says in so many words, the Secretary's discretion to disclose or not to disclose does not extend.
Can I ask you to slow down?
Sure. Does not extend to the public information list. It doesn't extend to refusing to give the public information list to a person who has qualified to access that list. That puts a limitation on the Secretary's discretion. And finally, so does subdivision 9. Subdivision 9 says that those particular categories of data shall not be disclosed to the public or to a law enforcement. All three of those provisions, the last part of the Secretary of State may sentence, the mandatory language in sub 5, and the mandatory language in sub 9, all of those put bridles on that discretion. Now, Mr. Cardall confesses to just confusion as to what this Secretary of State may thing, this language is supposed to mean. I confess I don't understand why it's so confusing. What this says on its face is that the Secretary of State is being granted statutory discretion. And again, the Carlson Court explicitly held that this grants the Secretary discretion to provide this information of public information lists and other information from the SVRS. So that set includes all of the stuff in the SVRS except the stuff in sub 9, and gives the Secretary to disclose that or not to disclose that except as otherwise limited here. I just don't see the problem. One necessary implication of this is that if someone is seeking information from the public information list but they don't meet these statutory requirements, let's say they're not a Minnesota voter. This person lives in Minneapolis but he has not registered to vote. Well, under the requirements of sub 4, that person is not statutorily entitled to access the public information list, but under the discretionary language here, the Secretary of State may provide that person with SVRS data as long as it's for the uses mentioned at the end of that sentence. That is a direct and necessary consequence of this sentence. Similarly, insofar as a request for information seeks information that's not on the public information list, this, by the necessary nature of the phrase, the Secretary of State may provide rather than must provide, the necessary implication of that, by that long list of case law that we've provided and the plaintiffs have not rebutted to any extent, necessarily shows that the Secretary is given discretion not to provide it. And again, that is the direct holding of the Carlson Court. Now, I get the sense now that there's kind of a new and novel argument that Mr. Cardall has represented the plaintiffs are making. That this case is not about, that they claim, it's not about accessing information that's off of the public information list. It's actually about massively expanding the boundaries of the public information list. What they're saying is that we need to redefine the terms registered voter and voting history so that registered voter includes all 5.4 million people we're talking about here, and so that voting history means effectively all of the information on each voter in the SVRS. Now, So what the argument then is that the plaintiffs are saying, actually, all of the stuff we are looking for is on the public information list. So the problem they are now contending is that the Secretary's concept of what the public information list is too narrow, is too limited. It's worth noting, again, this is directly contrary to the Carlson case, because if that were correct, email addresses would be part of this, would be part of the public information list as well. It's worth noting that that's directly contrary to what the legislature did earlier this year. Because again, what happened in the 2017 legislation is that Senator Kiffmeyer and a few other legislators attempted to add challenge status and the history of the SVRS status to the public information list. And the legislature said no. The legislature said, no, we are not going to put that on the public information list. It's also inconsistent with the 2016 revision putting the ballot choice on there. But frankly, the 2017 one is more potent because just like this argument now, that the 2017 legislation was an attempt to expand the public information list, and the legislature said no. So, but in terms, what they're saying is that, okay, first, registered voter means every voter in the database. As we put it out in our reply memorandum, we cannot understand how that makes any sense at all. First of all, that means dead people are registered voters, because the 5.4 million number includes a pretty large number, I couldn't tell you how many, dead people whose SVRS status is deceased. The necessary argument that they're making is, oh, well, those people are registered voters too, which, I mean, that's facially nonsense. Slightly less obviously problematic then is the argument that quote-unquote inactive voters are nonetheless still registered voters. And in the statutes, and we've provided in our materials the citations to the various statutory bases that there are for changing someone's SVRS status to inactive. Generally speaking, what we're talking about here, again, is people who have moved out of the state and are therefore no longer eligible to vote here. People who have moved to a new residence and so at least potentially are ineligible to vote in the precinct where they used to vote. And then people who haven't voted within the last 4 years. Now, under the explicit terms of Minnesota statutes, all of those people are inactive. All of those people are marked inactive. And anyone with an inactive status can't vote until they re-register. Now, one very happy thing in Minnesota is that we have election day registration. So someone with that inactive status who comes to their polling place on election day, if their status is inactive, it's okay. All they need to do is do election day registration and then they can vote. It's not a problem. But nonetheless, they still need to register. So you can see, at least where the rubber meets the road on this, in MnStat 201.171. I don't know if you've got that printed here or not.
No, I have a whole bunch of them here, but that one, 201.171.
That's correct. And that discusses various things. It discusses that last grounds for changing someone's status to inactive. It says that if the person hasn't voted in the last 4 years, then the Secretary shall change that person's SVRS status to inactive. There are other grounds for inactive. I mentioned them. They're in other statutes. But then the third paragraph of that statute says, registrants whose status was changed to inactive must register in the manner specified in the registration statute before voting in any primary, special primary, general, school district, or special election. What that's saying is that anybody whose SVRS status is inactive still needs to register before they are allowed to vote. A person who still needs to register before being allowed to vote is not a registered voter. It's a person who once was a registered voter, maybe, but that's not a registered voter. A person marked inactive is not a registered voter. And in our reply memo, we mentioned an obvious hypothetical example of this. Someone who moved to Arizona, who used to be a Minnesota registered voter, but moved to Arizona in 2006, hasn't come back, hasn't set foot here, hasn't submitted a ballot here, has just been living in Arizona, voting in Arizona for the last 11 years. Under under the definition of registered voter that the plaintiffs are offering here, that person is nonetheless a Minnesota registered voter for SVRS purposes. That doesn't make any sense. That's not the interpretation of registered voter that anybody uses. You could imagine.
But the secretary is still maintaining data about that individual and their voting history.
That's correct.
In the SVR.
That's correct. As they are for a large number of dead people, same way, yes. So that has to do with this argument about the term registered voter.
Can you point to a state statute, federal law, or temporary classification that renders data regarding voters who were once registered and eligible to vote and who are no longer registered to vote, rendering that non-public data?
Yeah. Yes, subdivision 4, first paragraph, final sentence. The Secretary of State may provide copies of the public information lists and other information from the SVRS for uses related, et cetera, et cetera, et cetera. It's not public. That's not public because public information has to be disclosed once requested. This disclosure of that information as other information from the SVRS is subject to the Secretary's discretion. That is the statute that makes that data other than public.
Okay.
So that's one way they want to expand the ambit of the public information list by redefining the concept of registered voters from something other than the way the statutes use it.
You've got to slow down.
Okay.
I have to keep an accurate record, and I can't do that if you're speaking that quickly. Okay?
Sorry.
All right, go ahead.
Then they also want to change the meaning of the term voting history. Now, voting history, as it's used in election administration, it's a pretty simple idea. It's the list of the previous elections in which a particular voter has voted. So my voting history would say that I voted in a municipal election in 2017, I voted in the state general election in 2016, and the primary election in 2016, and so on. That's what my voting history record in the SVRS states. The plaintiffs, again, with no legal support for this redefinition, want to argue, no. Voting history doesn't mean that. Voting history means the entire history of your SVRS record. So your status and all of the changes to your status that have ever happened in the SVRS, that's what voting history means. There's no basis for this in state law whatsoever. And indeed, every use of the term voting history, or the interchangeable synonym that the law sometimes uses, voter history, every use of that uses it to mean the list of elections. Voting history is something that county auditors have to post after every election just to keep track of the fact, here are the people who voted in this election. So there just isn't any legal basis to define voting history any differently than everyone in election administration defines it. This is just an attempt by the plaintiffs to expand what that means so they can expand the number of records they claim they can get through the public information list. The public information list only includes voting history as that term actually means, not this arbitrary definition they want to apply to it. Okay, I mean, a couple of other things. This so-called unbridled discretionary authority that Mr. Cardall complains that the Secretary is laying claim to here. The unfairness of it that he has mentioned is apparently it is unfair for the Secretary to provide SVRS information to county auditors, to local election officials, but not to these private folks who have nominated themselves as private election monitors. Well, I mean, to some extent, that just doesn't make any sense. Under Minnesota law explicitly, without any input from the Secretary, states that the system has to be accessible to the county auditor. That's in MnStat 201.022, subdivision 1.
I have that one.
Good. The final sentence of that first paragraph, the system must be accessible to the county auditor of each county in the state. So the notion that it's unfair to obey that statute, to give county auditors access to this information, which the law says you have to, but not to exercise the Secretary's discretion to give these plaintiffs anything they want from the database, that doesn't make any sense. The law Minnesota law very broadly makes county auditors and to some extent municipal officials the administrators of the state's elections. And they have to have access to this information. It's not the secretary's choice of whether those folks have access. That's the whole structure of our electoral system, that they have that information. Yeah, and I mean, in connection with that, Mr. Cardall mentioned that the secretary uses the challenge status on the poll roster to do X, Y, or Z. No, elections are administered by local officials. The secretary is not doing anything with that challenge status, except the secretary is the head administrator of this computer database. That's all he is in this case. Mr. Cardall has referred repeatedly to this, to the 1991 enactment of the Data Practices Act. That's interesting. All of the legislative amendments that we have documented in this case far post-date 1991. The legislature is perfectly well aware of how the DPA works and what it does and does not give people access to. And again, all of the legislative history we have here makes it clear. The legislature understands that when it comes to 201.091, the public information list is the stuff that's available to the public. The rest is not, at least presumptively, available to the public. That understanding suffuses everything. All of the discussion on that, on those amendments. So I believe that's all I've got for rebuttal. I'm very happy to answer any other questions that you have.
I don't have any.
All right, thank you.
Oh, I do. I'm sorry. Did you want an opportunity to submit a question for certification?
No, I don't believe that's necessary. This is the secretary's position is that this statute is clear, it's unambiguous, and I mean, just as the McGrath Court of Appeals held, the Carlson federal courts have held, it is clear how this statute governs access to SVRS data. And that conclusion is well within this court's jurisdiction and competence.
All right, I understand the secretary's position.
Thank you.
Mr. Cardall.
Your Honor, it concerns me that the Secretary of State would want this issue once and finally resolved immediately by the Minnesota Supreme Court. Again, the timing is important because there's an important election next year. The governor is up for election, the Attorney General, even the Secretary of State is up. So we want to have the best election next year as possible. And so MVA's concern is that thousands and perhaps tens of thousands of ineligible voters have voted in previous elections. And if so, can we as Minnesotans prevent that? We would hope that that would be the same concern the Secretary of State would have. But here we've asked for the information under the DPA, and it looks like we're entitled to it because it hasn't been designated as non-public. So the Secretary of State is not producing the data requested. So then the question for the people is, what inculpatory evidence is the Secretary of State hiding? Now, in 1991, after careful deliberation, the people had experience of decades of public officials withholding.
Sorry, if you have an electronic device other than the camera, you got to turn it all the way off, please, okay? Thank you. Go ahead,
In 1991, the state legislature heard stories of decades of public officials withholding inculpatory evidence. The state legislature deliberated on that question, and they said, we're going to enact the DPA so that the people have access to all government data unless it's statutorily designated as non-public. So the Minnesota Voters Alliance is entitled under the act to the inculpatory evidence that the Secretary of State is hiding. This scenario has repeated itself over and over again in townships, in school districts, in cities, and in counties, and the district courts have routinely enforced the Minnesota Government Data Practices Act against these government entities unless the data is clearly designated as non-public. Why is the Secretary of State any different when the Secretary of State, like these other government officials, has to comply with the Minnesota Government Data Practices Act? And we get today is an argument which in the end simply doesn't add up. Well, I've tracked down all these arguments, and they all lead to little rabbit holes. And in the end, it's always the same response, that the Secretary of State is obligated under the DPA just like any other public official. Thank you.
Before you sit down,
Sure,
Mr.
sure.
Cardle, if you would like until the close of business on Friday to confer with your clients and formulate a question, I'll allow you to submit a supplemental letter to supplement the record on this matter. If you submit it before Friday, I'll take the matter under advisement earlier than that.
All right, thank you.
Thank you,
Appreciate
Mr.
it.
Cardle. Anything else, Mr. Bernstein?
If you have nothing further to ask, I have nothing further to say.
I do not. Thank you very much for the argument. I appreciate the briefing. I'll take the matter under advisement upon the submission of Mr. Cardle's supplemental letter. All right, thank you, everyone.
Thank you.
We'll stand in recess.
Court will stand in recess.
Thanks, everyone.